The support order would be calculated on his verified income salary, bonuses, dividends, and trust distributions combined. That was the line Gerald Harrington's attorney stumbled over in court, but I'm getting ahead of myself. The morning his assistant called, I was finishing a 12-hour shift at the station. Not his son, not him. An assistant, measured voice, a Bay Street number. Miss Morrison, Mr. Harrington Sr. He would appreciate a private meeting at your earliest convenience. It concerns a personal family matter. I had responded to gas explosions in Scarborough and pulled people from overturned cars on the 401 inches January ice. I don't rattle easily, but I knew exactly what this was about. I had been seeing his son Daniel for almost 14 months. He was 44, divorced once, careful with his words in the way men raised around lawyers tend to be. He ran the Harrington Group's Western Ontario portfolio, commercial real estate, mixed-use developments, the kind of projects that get announced at City Hall press conferences with the mayor standing nearby. He had told me once that his family measured success in square footage. I had told him I measured it differently. He had laughed at that. It was one of the things that made me think he might be different from his father. When I told him I was pregnant, he didn't shout and he didn't leave. He sat very still at my kitchen table in the annex for a long time. I need to speak with my father, he said. I should have recognized that sentence for what it was, not a plan, a deferral. The meeting was at Gerald Harrington's office on the 31st floor of a tower on Bay Street. Floor-to-ceiling windows, a view of the lake on a clear day, the kind of room that communicates power without saying a word. His assistant offered me water. I declined. Gerald stood when I walked in, 71 years old, silver-haired. The posture of a man who had never once been told he was wrong by anyone who mattered to him. Miss Morrison, he said. We shook hands. He didn't circle the issue. That I respected, in the way you respect efficiency, even when it's aimed at you. He slid a folder across his desk. Inside was a certified check for $3 million, already made out, along with a non-disclosure agreement prepared by a firm I recognized from City Hall announcements. There was also a referral letter for a private clinic in Midtown. I've also arranged full aftercare, he said. Discreetly. The clinic is excellent. Discreetly. That was the word he used for what he was asking me to do with my child. I kept my hands in my lap. I didn't touch the folder. Daniel is not in a position for this right now, he continued. The Harrington Group is mid-transaction on 3 major developments. A complication of this nature could affect investor confidence, partnership agreements, and the timeline of projects that employ a great many people. A complication. I've been on scenes where I had to deliver news to families in parking lots and on front porches. I have told mothers their sons didn't make it. I understand what it means to choose your words carefully when the stakes are real. What he was doing was something different. He was choosing words that reduced a life to a line item. You want me to end the pregnancy, I said. He met my eyes. I want you to consider what is best for everyone involved, including yourself. $3 million provides significant security. Daniel will ensure there are no further difficulties. You have my word on that. $3 million, I said slowly. He nodded once. That figure reflects the seriousness with which we're approaching this. I looked at the check. I looked at the NDA. Then I looked at him. All right, I said. I'll take it under consideration. Something in his expression shifted. Not relief exactly, but recalibration. He had expected more resistance, or he had expected immediate gratitude. He wasn't sure which one I was offering. We'll need a decision by Friday, he said. I took the folder. I walked out onto Bay Street in the January cold, the wind off the lake cutting through my jacket. I stood on the sidewalk for a moment watching people move in and out of the towers around me. Briefcases, coffee cups, headphones, everyone absorbed in their own urgent version of the city. $3 million. For someone who grew up in a semi-detached in Hamilton with a father who drove a delivery truck and a mother who worked evenings at a call center, that number carries a different weight than it does for a man on the 31st floor. But I had been a combat medic in Kandahar when I was 23. I had seen what happens when people make decisions under pressure that they can't take back. The regret lives somewhere deeper than logic can reach. I knew what I was carrying. I knew what I was being asked to erase. That evening, I didn't call Daniel. I didn't call my mother. I sat at my kitchen table and pulled out a business card I had held onto for 2 years, given to me by a colleague whose custody case had nearly cost him everything before the right lawyer stepped in. The card said Patricia, Osei, family law. The phone rang twice. I was offered $3 million today, I said, to end a pregnancy. She was quiet for a moment. Are you safe? Yes. Do you want the child? I do. She didn't pause after that. Can you come in tomorrow morning? The appointment Gerald had arranged was at 9. At 8:15, I was sitting across from Patricia in her office near Bloor and Spadina, the folder open between us on her desk. She read every page carefully, turning each one without hurrying. They're asking you to waive paternity claims, child support entitlements, inheritance rights, and any future disclosure about the relationship or the pregnancy, she said. This clause here is particularly broad. It would prevent you from ever discussing Daniel Harrington in any context connected to this matter. He called it discretion, I said. She set the document down and looked at me over her glasses. Do you want $3 million? I want my child protected. She leaned back in her chair. Then you don't sign this. You file first. Explain what that means, I said. Under the federal child support guidelines, she said, support is calculated based on the payer's total income. For high-income earners, the court has discretion to depart from the table amount to ensure the child's standard of living reflects both parents' circumstances. She pulled up a worksheet on her screen. In addition, Section 7 expenses healthcare, childcare, education, extracurriculars are shared proportionally based on income. For someone with Daniel Harrington's income profile, she continued, and any trust distributions from the Harrington Group, we're talking about a number that compounds significantly over 18 years. More than $3 million? I asked. Structured, enforceable, and indexed, she said. Yes. And that's before we consider post-secondary contribution, which courts can order as well. She closed the worksheet. But here's what matters most. If you file first, before they can move this into a private arbitration framework, it stays in Ontario Superior Court, Family Division. Public record. Judicial oversight. A judge who answers to the law, not to the Harrington Group's board of directors. I thought about that. Control was what Gerald was buying, not just my silence, the outcome. He wanted to set the terms before any institution could. So if I file first, you set the tempo, she said. And once it's on the docket, they can't bury it. I looked out the window at the gray January sky. I thought about what it means to hold your position. In the field, you learn that ground seated under pressure is almost never recovered. You don't give up a position because someone offers you comfort. You hold until the mission is complete. What do? I asked. She folded her hands. Tomorrow morning, we walk into the courthouse on University Avenue, and we file a petition to establish paternity. And somewhere across the city, Gerald Harrington was waiting for a Friday answer he was about to receive much sooner than expected. The courthouse on University Avenue smells like photocopy toner and winter coats, fluorescent lights, rows of wooden benches, a bulletin board covered in legal aid pamphlets in a dozen languages. No marble, no private elevators. Just ordinary people navigating extraordinary circumstances with numbered forms and government-issued pens. Patricia stood beside me in a burgundy wool coat that had seen more courtrooms than I had emergency calls. She reviewed the petition one last time before we approached the clerk's window. Once this is stamped, I said. Ontario jurisdiction, she confirmed. They cannot move it to private arbitration. The father's income is subject to full financial disclosure. The court's priority is the child. The clerk took our documents, typed something into the terminal, and brought the stamp down. That sound was more final than anything said in an office on Bay Street. Outside, Patricia made a call to a process server. They'll be served at the Harrington Group offices this afternoon, she said. I thought about the assistant who would have to walk that paperwork into whatever meeting Gerald was running. Almost felt something about that. Not quite sympathy, almost. As we walked south on University Avenue, Patricia explained what would follow. In high-income cases in Ontario, she said, the court doesn't simply apply the table amount and stop. Judges look at the payer's lifestyle, corporate compensation, deferred income, trust structures. If they attempt to underreport, we can seek production orders. Courts here are not patient with financial games in family matters. That was something Gerald had miscalculated. He assumed I wanted the immediate number. $3 million feels enormous in the abstract. But permanence has a different value. A one-time payment buys silence. A court order buys accountability. My phone lit up on the walk home. Daniel, I let it ring once before answering. "What did you do?" he said. Not angry. Shaken. "I filed a paternity petition," I said. "Claire. That's the legal process, Daniel. That's all it is. My father is," he stopped. "His board is going to ask questions. Let them. The questions have answers." There was a long pause. "He thought this was going to be manageable," he said quietly. "It is manageable," I said. "Through the courts. That's what they're for," he exhaled. "You could have just talked to me." "I tried that. You told me to wait while you talked to your father. And your father offered me $3 million to disappear." Silence. "I don't want this to be a war," he said finally. "It doesn't have to be. But it will be legal. There's a difference between conflict and accountability." When we hung up, I sat at my kitchen table and put both hands flat on the wood. I thought about the check in the folder. $3 million made out to Claire Morrison. For a woman who had spent years sending money home to help her parents with the mortgage, that number lived in a different part of the brain. But I had seen enough, in enough places, to understand what purchase silence costs over time. There is no enforcement mechanism for goodwill. There is no court order backing a handshake. And children, especially children born into situations like this one, deserve more than goodwill. That afternoon, Patricia called. "They've been served." "How did he respond?" She paused. "According to the process server, Gerald Harrington went pale." I closed my eyes. That wasn't satisfaction. It was confirmation. For the first time, the situation had moved outside his control. The matter was before a judge. Provincial family law applied equally to delivery drivers and real estate dynasties. That was something Gerald had insulated himself from for so long that he may have genuinely forgotten it was true. That evening, I received a text. Not from Daniel, from Gerald's personal number. 3 words. "This is premature." I didn't respond. Sometimes the most complete answer is procedure already in motion. The preliminary hearing was scheduled within 3 weeks. Patricia had said they might request a delay, and they did. The court denied it. The night before the hearing, Daniel came to my door unannounced. He looked like someone who had not slept properly in days. I let him in. He sat on the couch in his coat, which he didn't take off, and looked at the floor. "You changed everything," he said. "I filed a petition," I said. "That's not a change. That's a beginning. My father has 3 partners asking questions about the Corktown development timeline. That's between him and his partners." He looked up at me then. "You don't understand what this family does when it feels cornered. I grew up in Hamilton, Daniel. I've been in places significantly more dangerous than a Bay Street conference room." He almost smiled at that. "Almost. I would have taken care of you," he said. That sentence landed exactly the way he intended it, and exactly the wrong way at the same time. "I know you believe that," I said, "but I'm not asking to be taken care of. I'm asking for my child to be protected. Those are not the same request." He leaned forward, elbows on his knees. "My father built everything he has by controlling outcomes before they become problems. I understand that, and that's precisely why I filed before he could." He was quiet for a long moment. Then, "I was afraid of what he'd think of me." "I know. I'm still afraid of it." "That I understand too," I said. "But here's the thing about being afraid of someone's opinion. The fear doesn't protect you. It just keeps you from making the right decision sooner." He left without any resolution between us. But he came back the next week, and the week after that, and each time the conversation was slightly less about his father and slightly more about what was growing on the ultrasound images I had started leaving on the kitchen counter. The family court hearing room is nothing like the version of courtrooms you carry around from television. It's quieter, more procedural. The judge, a woman in her early 60s with the unhurried manner of someone who has heard every version of human difficulty, reviewed the filings without theatrics. "Petition to establish paternity," she said. "Motion for DNA testing. Request for full financial disclosure under the federal child support guidelines." She looked up. "Is there any dispute as to potential paternity?" Harrington's senior counsel stood. "No, Your Honor." Just like that. No performance, no maneuvering. Just acknowledgement. The judge ordered DNA testing within 14 days and financial disclosure within 30. She looked at Gerald's legal team. Given the income representations provided, the court requires complete documentation of employment income, bonus structures, trust distributions, and any corporate compensation arrangements. I watched Gerald in my peripheral vision. His jaw was set, but his hands on the table were still in the careful way of a man exercising significant control over himself. All motions to transfer this matter to private arbitration are denied. This court retains jurisdiction. Denied. That word settled into the room the way significant words do, without echo, without drama, just weight. After the hearing, Gerald walked toward me in the corridor. It was the first time he had approached me directly since the Bay Street meeting. He looked the same in every visible way, but something in his bearing had changed by a degree or two that I recognized from people who have just had the ground shift under them. "You've introduced complexity that didn't need to exist," he said evenly. "I introduced transparency," I said. "The complexity was already there. You could have walked away financially stable." "I will be," I said. "Stably and with legal protection." He held my gaze for a moment longer than was comfortable. Then he turned and walked with his attorneys toward the elevator. Patricia touched my arm. "You did well." "I didn't do anything," I said. "The court did." That distinction felt important then and still does. The DNA results came back on a Thursday. Patricia called me while I was making breakfast. "Confirmed," she said. "Paternity established. No surprise, no drama. Just a lab report filed with the court, and suddenly everything that had been alleged became obligation. The financial disclosure package arrived in stages over the following weeks and was substantially more complex than I had imagined. Patricia walked me through it in her office. Salary, year-end bonus history, deferred equity from 2 Harrington Group subsidiary companies, trust distributions from a family trust established in 1987, rental income from properties held personally. She laid the documents out in sequence the way you might lay out a map before a complicated route. Under the federal guidelines, she said, the base support amount is calculated on the payer's total income from line 150 of his tax return. For income above the table maximum, courts apply their discretion to determine an amount that is appropriate and just. She underlined a figure. This is the projected annual amount, conservatively calculated, before Section 7 expenses. I looked at the number. $3 million, I said quietly. One payment. She nodded. Versus this, she said, pointing to a column. 18 years, indexed, enforceable, with a court order behind it. There are things you understand abstractly, and things you understand only when they're written in columns in front of you. Daniel called that evening. He sounded different from the previous calls, less defensive. More tired in the way that sometimes means a person is coming through the other side of something. "The disclosure was harder for my father than I expected," he said. "Being accountable is hard for people who've avoided it for a long time." He was quiet. Then, "I've been thinking about what you said. About protection not being the same thing as taking care of someone. What did you conclude? That I've been letting him protect me in ways that were really just about protecting him?" I didn't respond right away. There are moments in conversations where the best thing is to let the sentence finish settling. "I want to be present," he said. "Not as a legal category. Actually present." "That's a different conversation from the one we've been having," I said. "I know. I'm asking for it anyway." We talked for almost 2 hours. About schools and pediatricians, and what shared custody looks like when 2 people don't live together but do want to do right by a child. It was the most functional conversation we'd had since I told him I was pregnant. The financial compliance conference before the judge 2 weeks later was largely procedural. Andrew Caldwell's compensation had been extensive. Daniel Harrington's was as well, and the court's manner of treating it was identical, dispassionately, mathematically, without regard for who the Harrington Group employed, or what developments were midway through approvals. The judge reviewed the documentation. She noted the trust distributions, the deferred equity schedule, the year-end bonus history. She looked at Daniel directly. "Are these figures complete and accurate to the best of your knowledge?" "Yes, Your Honor." Gerald shifted slightly in his seat in the gallery. "Given the verified income, the court will set temporary support effective immediately, pending final calculation." The judge placed her pen down. "I want to be clear about the court's position. A child's right to financial support is not contingent on the convenience of the parents or the strategic interests of related parties. It is a statutory obligation. This court takes that seriously. Statutory obligation. Not charity, not goodwill. Law." Harrington's attorney attempted something in the margins. "Your Honor, the parties have previously discussed a private settlement arrangement." The judge raised one hand, not sharply, simply firmly. "Private arrangements are not enforceable by this court. Statutory obligations are. The children's interests are this court's priority. As we left the courthouse that afternoon, the sky over University Avenue was doing what Toronto skies do in February, gray and indifferent, and somehow still beautiful in a muted way. Patricia was reviewing notes beside me. Gerald Harrington approached from behind. He waited until Patricia had stepped a few feet ahead before he spoke. You ensured this became a matter of record. I ensured it became a matter of law, I said. There's a difference. You could have resolved this in a room. Rooms don't issue enforceable orders. He was quiet for a moment. The wind pushed at both of us. I underestimated you, he said. That was a fact, not a rebuke, and I treated it as one. Yes, I said. You did. He didn't respond to that. He walked back toward his car, and I watched him go. And I thought about what Patricia had said once about the difference between winning and establishing precedent. The weeks that followed moved the way legal processes do steadily, with paperwork marking time in place of events. The final support hearing was set for late spring. By then I was 6 months along and running calls was off the table. I was on light duties, doing dispatch and training. The nights were long and quiet in a way I wasn't used to. Daniel visited twice a week. He stopped arriving with things to say, and started arriving with questions to ask. What kind of crib? What kind of stroller? Whether I had a preference for the hospital. Practical questions. Participatory ones. One evening, he arrived with 2 flat-pack boxes from a furniture store, and we spent 3 hours putting together a dresser in what would be the nursery, arguing about which way the instructions were oriented, and I thought, this is what it looks like when someone chooses to show up. The final hearing was a Thursday in late May. The city was warm for the first time, and people had come out of their winter selves a little. The courtroom felt different from the February hearings. Something had resolved, at least in terms of the people in it. Gerald arrived with only one attorney. Daniel sat at counsel table alone. Patricia and I took our seats across from them. The judge reviewed the final financial calculations with the same methodical calm she had brought to every previous proceeding. The support order was structured clearly. Base monthly amount under the guidelines, plus proportional contributions to Section 7, expenses covering childcare, healthcare, and education, plus a post-secondary contribution framework to be revisited when the time came. A life insurance policy naming the child as beneficiary was required to secure the support obligation. The total projected obligation over 18 years exceeded the $3 million figure offered at the Bay Street meeting, not by a small margin. Daniel swallowed visibly. Gerald's expression didn't change, but I had learned to read the small tells. The judge then addressed custody. Have the parties had discussions regarding parenting arrangements? Daniel stood. Yes, Your Honor. We're proposing shared legal custody with primary physical residence and structured parenting time, expanding as the child develops. He glanced at me briefly. Patricia stood. My client agrees in principle, contingent on the court incorporating compliance mechanisms and review provisions. The judge approved the framework subject to a finalized parenting agreement. Then she said something I wrote down that evening and still have. A child does not choose their circumstances. But this court can ensure that those circumstances, whatever they are stable, supported, and fair. That is not a favor extended to either parent. It is a right belonging to the child. The support order was entered into the record. Temporary payments converting to permanent trust contributions earmarked for education and healthcare, enforcement provisions attached. As we filed out, Daniel reached me before Patricia did. I handled this wrong from the beginning, he said. You handled it the way you were taught to. That's not an excuse. No, I said, but it's a reason. Reasons and excuses are different. He nodded slowly. I'm more afraid of getting this wrong, he looked toward my rounded abdomen, than I've ever been of anything my father thought of me. That's growth, I said. Not dramatic, not sudden, but real. Gerald was waiting near the corridor, hat in hand in the literal way, which struck me as unusual. I owe you a direct statement, he said. All right, I acted with the intent of protecting my family's interests. He paused. I treated your child as a liability before she existed. That was wrong. There was a steadiness to the way he said it. Not performance. Not negotiation. Acknowledgement. I didn't soften it for him. It was wrong, I agreed. But we're here now. He looked at me for a moment. You filed first. I did. I was furious, he said. And then I was accountable. And then he paused. I had to think about what I actually wanted. What did you decide? He straightened slightly. To be useful. In whatever way is appropriate. We shook hands. Not warmly, not coldly. Appropriately. My daughter was born on a Saturday morning in early July. No announcements, no press, no drama. Just a hospital room in the annex neighborhood. 2 nurses who knew exactly what they were doing. And a morning so bright it felt deliberate. Daniel was there. He stood in the corner at first, uncertain where to put himself, a tall man in a small room full of competence. When the nurse placed her in his arms for the first time, something happened in his face that I had never seen in 14 months of knowing him. All the calculation went out of it. He just looked at her. Gerald arrived 2 hours later. He came alone, carrying a small gift bag from a children's bookshop on Harbord Street. He stood at the door, and I nodded him in. He looked at her for a long time without saying anything. She has her mother's expression, he said finally. She's about 4 hours old, I said. He glanced at me. Something in his face was different from every previous version of it. Not diminished. Rearranged. May I? He asked. It was the first time he had asked me permission for anything. I nodded. He held her with the careful stiffness of someone who understood he was holding something irreplaceable and was not sure he deserved to. Later, after Daniel had stepped out and Gerald and I were alone in that particular quiet that hospitals carry, he said, I spent 30 years building things I was proud of. He didn't look at me when he said it. He looked at her. And I nearly made the worst decision of my life because I thought I was protecting them. You were protecting your version of them, I said. He was quiet for a moment. Yes, that's right. He adjusted the blanket around her small shoulders with a care I wouldn't have predicted from the man who slid a cheque across a mahogany desk 6 months earlier. I've asked my estate lawyer to revise my will, he said. She'll be named directly, not through Daniel. You don't have to do that. I know. The silence between us was not uncomfortable. It was the silence of 2 people who have been through something difficult and arrived somewhere neither of them anticipated. I was wrong to treat her as a problem, he said. She wasn't a problem, I said. She was an obligation. The problem was your relationship with obligation. He allowed himself something close to a smile. That's very precise. I work in emergency medicine, I said. Precision matters. In the months that followed, a kind of ordinary life assembled itself. Not the life I had imagined a year earlier, but a stable one. Daniel moved to a condo 8 blocks from my apartment. We worked out a parenting schedule across the kitchen table, over 2 evenings. No lawyers, just calendars and coffee. Wednesday dinners, alternating weekends. Shared presence at medical appointments without tension turning the air in the room. Gerald came on Sundays. He arrived around 11, usually with something from the bookshop or a puzzle he had decided she was old enough for. He sat on the floor without being asked. He read to her in the serious tone he probably used in board meetings, and she seemed to find this appropriate. One Sunday, he asked to speak with me privately for a moment, while Daniel took her for a walk around the block. I've been in contact with the Canadian Armed Forces Foundation, he said. I'd like to establish a fund supporting childcare access for single service members and veterans. I looked at him. Why? Because I spent a great deal of time this past year realizing how little I understood about what certain people endure, and how easily I dismissed what I didn't understand. He folded his hands on the table in the way he must have done 1,000 times in rooms that smelled like expensive carpet. I won't claim it erases what I tried to do, but I can decide who I am from here. That's all any of us can do, I said. Patricia told me later, when we met to review the annual compliance documents, that Harrington's legal team had spent the weeks after the initial filing preparing for a protracted fight. They had researched every available avenue, every delay mechanism, every procedural option. And now? I asked. Now they're revising an estate plan and setting up a charitable fund, she said. She looked at me over her glasses. You filed first. I filed for her, I said. Patricia smiled. That's the same thing. The $3 million check expired in a desk drawer sometime in the spring. I shredded it on a Tuesday evening while my daughter was asleep, not with ceremony, just as a task on a list. It had represented silence purchase before I understood its full cost. The court order behind it represents something that doesn't expire. She's 3.5 now. She has opinions about which coat she wants to wear and strong feelings about which stories count as acceptable bedtime reading. She doesn't know anything about Bay Street offices or certified checks or federal child support guidelines. She knows her father makes excellent pancakes on Wednesday mornings and that her grandfather sits on the floor when he reads to her, even though it takes him a moment to get back up. That is exactly the point. If you have ever been in a position where someone with money and influence tried to manage you out of a situation that was never theirs to manage, if you have ever been handed a check in a folder and told it was generosity, I want you to know something that took me time to understand fully. Accountability is not aggression. Structure is not a weapon. Filing first is not an act of war. It is an act of protection. And protection, especially when it is for someone who cannot yet protect themselves, is the most responsible thing you can do. The law didn't win. It worked. Those are different things. It worked the way it was designed to work, for people who show up and use it. That's not a small thing. In a country that extends that framework to everyone, it is one of the most important things we have. Gerald still visits on Sundays. Last week he arrived with a junior hockey set he had decided she was ready for. He assembled it on the living room floor with far more precision than the task required. When she scored her first goal against him, he raised his arms like it had actually counted for something. It did, I suppose. There are moments when the right outcome takes longer to arrive than we think it should. But it can arrive. I've learned that structure is what makes it possible, and showing up is what makes it real. The billionaire went pale the morning I filed because he thought he was losing control. What he was actually losing was an illusion. The illusion that some people are above accountability. Accountability doesn't destroy people like him. Sometimes, when everything else is stripped away, it clarifies them. And sometimes that's enough.